pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Yeah.
No, but isn't she here?
Yeah. All right. First order of business is next month's meeting was scheduled for March 16th. Right, I won't be able to make that. So I'm looking to do it March 2nd or the 23rd. Is March 2nd preferably. Is that okay with everybody? Second. Have a problem with that? Mr. Rob?
March 2nd is fine.
All right, then next month's meeting will be Monday, March 2nd here. Okay. First order of business is Alex Campbell, 4 Cliffside Court, Garrison, New York. Applicant seeks relief from requirement to provide a front yard setback of 50 feet from the center line of the traveled way in front of the subject property. The partially constructed residential structure has a setback of 37.2 feet from the center line of the existing traveled way and 36.2 from the center line of the right-of-way. Appellant therefore seeks a variance of 12.8 feet. Are you representing him?
I am, thank you.
Yes, go ahead.
Glennon Watson from Beatty and Watson. The application that we've given you the application package for the variance, essentially, as you read it in the appeal application, the building has been placed too close to the road. It's virtually complete. The walls are on the inside. It was discovered very late in the process. It's explained in the application package. I'm here really tonight to just ask you to find it complete and schedule a public hearing, at which point I'll present a more cogent argument.
All right. I don't see, do you have a list of the neighbors here?
I believe so. If not, I certainly can have it
Let me
to you
see.
tomorrow. There should be a list of adjoiners.
Anybody have it?
It's typically be on the back of the application.
Yeah. I don't see it. Let me see. Oh, it's here. You're right.
Had
I
me
should
going
know.
there for a minute.
I know. You're right. You're right on the balls always. All right. I think everything is here. It looks complete to me. Does anybody have any questions on this application? No. Anybody? All right. So make a motion that the application be accepted complete and deem it for a public hearing on March 2nd. Do I have a second?
Also move.
All in favor?
Aye.
All right. All right. Anonymous, March 2nd will be here.
Thank you very much. Good night.
Thank you. Good night. Okay. Got the house built in violation. All right, let's see. Next order of business is, next one is Jared Delval, 117 Round Hill Road.
Roland Heitman representing Jared. We basically are requesting a variance for a larger garage than 1,000 square feet.
Right.
Heitman, Heitmann.
I saw it looked like everything was there, but I didn't see a list of neighbors. Did you put a list of the surrounding properties?
I thought Kelly was going to help me with that, but I have the deed by email. It's just, I didn't want to print it because it's like 200 pages. I wasn't sure exactly what you want. Yeah, it was a crazy long deed that the owner provided, so I just wanted to know what you really wanted for that, because I can't imagine you wanted.
We have to know you own the property, that's the first thing. We need the deed.
Okay.
I don't need 200 pages of it, but maybe if there's any.
Okay, I have it by email. I can email it in the morning. I could email it now from my phone, just,
Well, email it to Kelly, and then she'll
yeah.
prepare it for next meeting. And then, you got the building plans are here.
Yep.
And she's gonna help you with the list of neighbors, you said, right?
Yep.
Okay, because that has to go out in the paper and all like that. People have
Right.
to be notified and everything else like that. A second. Is this picture, is that what you intend to put up? Is that what this picture is?
Yeah, that's what it would represent. It's basically kind of, it's a sloped hillside, and it's kind of embedded in the hill. Yeah, so it's very, very inconspicuous. That's what it would look like when complete.
Okay,
Similar design to the house. The house is similarly tucked into the hillside.
right, okay. Double check everything here. Well, I don't see that, there's a thing called the 5 factors, where's the questions, let me see if you answer them here. Hold on.
I thought we answered
Oh, yeah, you do
them in
have,
the
it. Yep, you have
application.
it, yep, you have it. Okay, anybody have any questions on it, the completeness? All right, okay, I make a motion that it be accepted as complete.
With the deed, with the inclusion of the deed.
Yeah,
With the
well,
inclusion
I
of
can
the
send
deed.
that to Kelly,
Right.
Kelly in the morning.
And, second? Yep. All in favor? You'll be set up for a public hearing for March 2nd,
Okay, great.
okay, here at 7:30.
Okay, thank you. Thank you very much.
Okay, the next order of business is Michael Kinsley, 8 Ferris Drive. Applicant is seeking approval to construct a new addition 18 by 30 foot to the rear of the house, where a portion of the additional lands within a setback of the side yard, as seen on the property survey. The existing house shows to be 22.2 from the property line at the rear of the house. Therefore, a variance of 7 foot 10 inches will be needed for the proposed addition, which is found under Town Code 175 SR zoning district. We looked at your plans and all like that, we for completeness last week and everything like that, and you pretty much explained it, you're kind of squaring off the house.
Exactly, yes.
Right. The only thing, is there anybody here who want to speak on to this, regards this question? Any neighbors or anything else like that? All right, so you look like you have no opposition, so that's a good thing.
That's a good thing.
Doesn't happen too often, but that's a good thing. All right, let's just go over the 5 factors here that you put in here. You did that as a supplemental worksheet, all right. The first question you answered is, the proposed addition will not affect any adjoining properties in a negative way. It will not be a hindrance to the neighborhood. The adjoining property is the north 6 Ferris Drive, which is 122 feet away, is the closest point to the rear of the house. The adjoining property to the south is 10 Ferris Drive, which is 115 feet to the closest point. Well, evidently, there doesn't seem to be any problems with the neighbors, because there's nobody here. We give them ample opportunity to respond, so. Number 2, the proposed addition will add to the character of the neighborhood and will be done in a similar fashion to houses in the area. 8 Ferris Drive is one of the last houses on the block and has not been changed or altered from the time it was built in the late 1950s. The house is all original, needs a lot of work on the exterior and interior, so the work will only benefit the neighborhood. Location of property, addition to the rear of the house, is the best possible location. This part of property is flat with surrounding bedrock, as the rest of the property has a much steeper grade along the front and side lines of the houses with bedrock and existing patios. The reason I want the variance for the small portion that lands within the setback is to keep the house square at the back. The code that must be taken into consideration is the side yard setback, as stated in Chapter 175. There must be 30 feet clearance from the side yard of the house. As shown in the survey, the corner is only 22.2 from the side, but that was originally there, right?
That's existing.
That's the original, that's an existing point at the
Correct.
house, okay. So you're looking for a 7 foot, 10 inch variance. Correct, okay. The piece of property where the addition is going will not require any blasting or removal of trees. There are no water resources or wetlands that will be altered in any way. I've owned a house since February 2013 and was purchased as is with no work being done since. The only work is needed to increase the square footage of the house and add a bedroom for my daughter. Okay. Does anyone have any questions on this? Anybody have any questions? And there again, there's no one in the audience that has any concerns. So at this point in time,
Can I ask?
Sure.
What's the total square footage of the house right now? And
As is now, existing, it's about 950 square foot.
oh, and then, you're adding how much?
It's going to be 18 foot by 35 foot wide, but a portion of the existing house already sits within that,
Yeah.
which is 9 foot by 14 foot.
Okay. So, do you
The
know
square
what-
footage is all listed on the,
Yeah,
on the prints there.
okay. Do you know offhand what it would be, or?
I do not know.
Oh, okay, all right.
any other questions? Anybody else? I don't see any issues here. Can I get a motion to accept the variance, or approve the variance?
I'll second.
Make
Make a motion.
Make the motion, okay. Can I get a second?
A second.
All in favor?
Aye.
Okay, it's approved.
Great.
Now,
Thank you.
you're gonna have to wait for the resolution, or maybe you could use the minutes, you know, it's up to you, but you speak to the building, zone code enforcement officer, and he'll tell you how to proceed.
Okay, great. Thank you.
Okay, thank you, good night.
Have a good night.
Good to close the public hearing first?
Do I?
Do we have to close the public hearing before we vote?
No, it's not, oh, yeah, that's right, good. This time, I make a motion to close the public hearing.
Make a motion.
All in favor?
Aye.
Aye, motion, public hearing is closed. Okay. Next order of business.
I'm gonna recuse myself.
You're gonna recuse yourself, okay. This is Route 529, Route 9D. Well, we received new information on, this is a continuation of a public hearing. We received new information on this from both attorneys. So I guess I'll give the attorneys a chance to speak first. I'm going to change that. We did a site inspection, the board, at both locations, 529, Dr. Romero's and Mr. Otisak's next door. And well, I'd like to speak to Mr. Russell. Can I speak to you or your attorney, whoever wants to speak for him? I have some questions. Hi. Well, when we did a site inspection, I know the question was about the loft, okay? I know it had been raised before. And I think in the board's opinion, the loft was not able to be used for living space, okay? I don't see it how it could be. You can walk up there, you can stand up there and all like that, but it's not big enough to be a living space. The basement, to me, was an issue, and I'll tell you why. Okay, because your plan was you had an unfinished basement, and then you were gonna, and you had a finished basement, I'm sorry, a finished basement that you were gonna unfinish, okay? And then you were gonna use that as a whole second story of your home. Correct? Okay. Like I told you when I saw you, that there's no CO or no building permit for a finished basement. So therefore, I find it's difficult to me. Unfortunately, the building inspector's not here tonight, but I don't know how you can include that on the second story if you don't have a CO or a permit for it to begin with. Maybe the attorney can answer the question.
There are a couple of issues that I did want to bring up in regards to this. I think that this is being based off of the
Can
assessment
you
card.
answer that question first?
Yes, yes. The assessment card reflects that there's a bathroom and a half. The half bath was located in the basement. So I don't know where the discrepancy comes with not adding it to floor area. I
Well,
think
if it's
that's,
not a CO, or if there's not a building permit for a finished basement,
and the building department found that it was legally pre-existing.
how could they do that if there's no CO?
If it was built before the code, it wouldn't require one.
If it was finished before the code, is that what you're saying?
Correct. So if at the time the basement was built, there was no code requiring a building permit and certificate of occupancy, it would be considered a non-conforming basement that is legally pre-existing.
What year was it built?
I'm not sure.
How do you
The house
know?
was built in 1963. The assessment card reflects at that time there was a bathroom and a half. That half bathroom was in the basement. The assessment card also reflects that there is area in the basement. The discrepancy is whether that area was added to the specific portion of the assessment card, which states floor area, I believe, but it was listed on the assessment card as being an existing basement.
See, there's an issue there, because when I looked at that card, what day did you look at that?
Today. I received it today, and I looked at it today.
I looked at it from after the night of the meeting, and it said it was just 1,200 square feet. There's nothing about a second basement.
I respectfully disagree with that, Mr. Chairman.
I disagree with it. It's what I looked at and I saw with my own eyes, so I
And-
don't know
and
what
the
happened
cop-
between then.
The copy that I was provided with today, I'm sure it was just a scanning mistake and nothing more so than that. But there is a portion that should be underneath square foot of living area to reflect that area. It's not here on this one, and I'm sure it was just a scanning error. Maybe the fax machine didn't quite get it. But whether or not those two numbers were added to be square foot of living area, in my eyes, does not make a difference. Because also, you'll see that it lists number of bathrooms as 1.5. And the one bath was on the first floor, the half bath was on the lower floor. And regardless, the code is very, very clear when it comes to non-conforming structures. We're not a non-conforming use. We have one nonconformity, and that's with the side yard setback on the left-hand side of the property if you're facing the house. It's a residential use in a residential zone. The code is clear, section 175-23B1. Nonconforming buildings or other structures shall not be enlarged, extended, or structurally altered except where the enlargement or extension does not increase the nonconformity. There's one nonconformity here, and it's with side yard setback. So long as any building does not move closer to the side yard, we're not expanding the nonconformity.
Correct.
And
I guess the issue, just to,
Now read 175.
to speak to the, for the record, there's a provision that provides that a structure that's pre-existing cannot be increased in size by more than 25% of the gross floor area. I'm not sure if I'm,
Excuse me, I believe that's if you seek a variance, but we were not doing anything that needed a variance. So if we were applying for a variance, if I wanted to build a garage in the future in the side yard setback, then I would come back to the zoning board and say, can I have up to 25%, because I'm increasing the nonconformity? And at that time, then you could tell me yes or no, and the neighbors could object or not. I feel very strongly that the permit was issued as of right, because we didn't increase the nonconformity of the structure, as my attorney just mentioned.
well,
Let me ask-
just to be clear, I'm referring to section 175-23B2, which I believe your counsel is familiar with. I just wanted
Yes.
to give you the opportunity to make a record, because I understand one of the concerns is that by doing what you're doing, you are increasing the floor area or impervious surface coverage by more than 25%. At least that's one of the contentions raised. So I think that's the concern, and I'm just giving you an opportunity to speak to that claim, because there obviously is a question by the board.
No,
on that.
and I thoroughly understand the point that's being made now. And if we go to B2, that's under the assumption that we did not substitute the floor area from the basement to the top, if my recollection of the code provision itself off the top of my head is correct.
Let's see, so notwithstanding revisions of B1 above, a non-conforming use or structure may be enlarged by a maximum of 25% of its floor area, or by impervious surface coverage, whichever is less, by the grant of a special permit by the Zoning Board of Appeals, provided that the board finds the enlargement will not have a greater impact on neighboring land use and the public and existing use or structure, that the enlargement will improve the appearance of the site, and the enlargement will comply with applicable site plan criteria to the extent practical, and further provided that in case of proposed enlargement of a non-conforming structure used legally for business. So I guess what we're trying to say, the question is that, was it increased more than 25%? Because you're saying the floor area, the basement had a bathroom. Okay. There's no building permit or CO for a finished basement. Is that correct?
Correct.
Okay. So my question is, how can it be added as a second story if the basement was never living space?
I don't think that we can rely on an assessment card to determine the
I'm not
legality.
relying on an assessment card, I'm relying on the file from the building department.
And if at the time the structure was built, there was a finished basement and it was before the code, then it would be a legally pre-existing use.
How would we know that?
That would be from the building department.
Building department says there is not a CO or not a building permit, so how would we know that is my question to you.
I think it would be very helpful if we could speak with someone from the building department in regards to this question specifically.
Okay.
And I would also like to make the argument, beyond the merits of what we're discussing this evening, I think the board really needs to look at the case law, and you need to look very firmly at the 60-day requirement of filing an appeal. I have not been given any contrary law. I have not been provided any set of facts that to me would appear to change the longstanding precedent that's here in the Second Judicial Department. That's binding on us. As I've mentioned, the case of Peel versus Cold Spring, it's the municipality just north of here.
Correct.
The Village of Cold Spring, their zoning board denied an appeal based on timeliness.
Correct. 1 second. I know you mentioned that a couple of times last month, so I looked it up. That appeal was filed almost 3 years after.
But the holding,
I mean, but it says, is that correct? I could be wrong. You're the attorney, not me.
And it was for a shed.
And it was
course.
almost 3 years after.
and
Okay.
I did in my initial submission provide a number of other cases. I do think
Correct.
that it's important to look to ones that are geographically close to us, and particularly ones that have binding case law that's in our judicial district. That case was denied at the zoning board for untimeliness. It was appealed to the Putnam County Supreme Court by Article 78. The Supreme Court agreed with the zoning board that it was denied due to untimeliness. It was then appealed again to the appellate division, which reaffirmed that it was properly denied due to untimeliness. And again, I don't see a set of facts here that distinguish these two cases that would make the appellate division's second department change their longstanding case law. This is a standard that's well understood across the state, and it's particularly binding here on us.
Question. If the applicants went to get the building department and were denied the paperwork, would that have anything to do with it?
To be frank with you, Mr. Chairman, I do not find it persuasive that the applicants had retained counsel nearly a month in advance of when the application was due, and that an application was not submitted on time.
Okay. Anything else? Anything else?
Yeah, I mean, I just like to state again.
Oh, wait, I'm sorry, I'm finished.
Sure.
I forgot something. On the site inspection, now, as your attorney, if this was finished and he gets a CO for the house and so on and so forth, in order to finish the basement, which would mean he would be including 25% more space, he would have to come before the zoning board for a permit. Is that correct?
I don't think so.
You don't think so?
No. Can I,
Go ahead. I'm just saying,
But-
maybe
but
I'm
I-
wrong. Maybe I'm reading the wrong book. It's possible.
I think the building permit was issued as of right, and the zoning variance was not required, because the second floor doesn't increase the dimensional nonconformity of the house. It stays within the existing footprint and does not expand any closer to the neighbor's lot line.
I got that.
Or any other nonconforming
You don't have to
structure.
go through all that.
Yeah.
We understand that.
So-
We agree with you on that. What we're
so-
trying to say is that you don't think that you have to come back before us to finish your basement. Is that what you're saying?
I would have to go to the buildings department,
Not us?
because how would, if I'm finishing the basement, would I be increasing the nonconformity of the structure?
Of course, you're doing more than 25%.
Well, then we would get into a totally different scenario than where we are now. And I would much prefer to deal with what's before us as opposed to hypotheticals. If Mr. Rassick wants.
I'm not dealing with hypothetical. This is the reason I asked you. The reason I asked you is because when we went to do the site inspection, the basement was being finished.
I disagree.
How do you disagree?
Because
Were you there?
I was not there. I've seen
Okay.
multiple photos of the premises. Unfortunately, I was not there when the board made their visit. I certainly would have liked to have been there.
You disagree, I mean you weren't there. Let me explain to you what we saw. Okay, what we saw was that all studded out, the walls were all studded out, there was wooden partitions. We spoke to the contractor says he was in the process of spraying foam insulation and putting up sheetrock and electric. Now, to me, that's a finished basement. And he would have to come back here to get any more than 25%. Do you understand what I'm saying?
I do understand.
Okay.
And
And your
would-
argument to that is what?
that as of this moment in time, right now, I would have to review the Town of Philipstown code for what the definition of basement is and what the definition of finished is. I don't think it's indicative that by adding insulation, that a basement automatically becomes finished. I think that.
You don't think that sheetrock and insulation and electric and studding is a finished basement?
I think that determining on how far all of those items go would.
What do you mean by how far? All the walls, the ceiling, how far? I don't
I-
understand that.
Anecdotally, using examples, I think that we've all been in basements where there's sheetrock on walls, where there's concrete on the floor, where there's maybe a steel lolly column, and that would be very well considered an unfinished basement. But again, I don't have the code provision in front of me, and I'm not prepared at this moment to make an argument about the potential finished basement. The building permit that was granted essentially unfinished the basement, used that floor area, moved it to the second floor.
Right. Well, I'm gonna ask the building inspector to take a look at it, because in my opinion, he's in violation of building permit by doing a finished basement.
And again, I'm sure that the building department would require an inspection once work was complete to make sure that it complied with the building permit, to make sure that the work that was done was legally authorized, and I'm sure that that would take place. The issue that I'm having here is that it is undisputed that this appeal was delivered late. And in my perspective, from my point of view, whether it's 1 day late, 30 days late, 3 years late, if you start to make exceptions of the rule, then all you're going to do is muddy the waters. Right now, there's a very clear-cut rule. If I go to the Town of Philipstown building inspector and ask for a building permit and he denies me, right then and there, I know he denies me, I have 60 days to file an appeal. Now, if I go to the building department and the building inspector denies me, gives me the permit, but my neighbor has no idea of that permit. They don't know until I start working on it. From that date of actual or constructive knowledge, that person has 60 days to file the appeal. The law is clear, and I have not had anything presented to me to the contrary. I understand the contention that allegedly the applicant was denied at the building department. I have a hard time believing that when counsel was retained in early August. Please.
Well, in my opinion, well, first of all, we in Philipstown try to be people-friendly, and we try to provide good service to people who come before us. In my opinion, the applicant was not accorded appropriate help in getting his complaint put forward. Perhaps it was not the fault of anyone in the building department, but it occurred. And so for that reason, I don't see that the time period should begin on July 24th, because they were not accorded the services that we normally provide on July 24th. The attorney for the complainant is saying that the 60-day time period should start on August 12th when they were there. which would put this claim in the period of 60 days. So my opinion is, due to the confusion or whatever at the building department, the client was not, the time period should not start on July 24th, and I don't believe it was untimely.
If I may, how do you square that opinion with the well-settled precedential case law that is binding on us here in Putnam County?
I guess the judge would have to decide
Yeah,
that, probably,
right.
78 or something like that. That would,
Right.
if that's her opinion, that's her opinion. You know, this is the board, and she's entitled to the way she can interpret it. And she interprets that way, a judge would have to decide at the end. Okay?
Okay.
Anything else, sir?
Unless there are further questions from the board, I maintain that this building permit was legally granted, clearly within the language of 175-23B1, and it is clearly untimely and in violation of the law if this application were to be heard any further. And of course, after Mr. Hilbert and his clients have the opportunity to speak and address the board this evening, I would respectfully request that the public hearing be closed and that it be set for a vote.
Okay, thank you.
Thank you, Mr. Chairman.
Mr. Hilbert?
Yes, sir. Luke
I got
Hilbert.
I got your new
Thank you.
read.
Yes, and I apologize when the letter I sent over today, when I went to the building department, initially the file had a building permit application actually from my client's house. And so they were the ones who pointed out the error, and then I went and tried to, I guess I retraced some of your steps.
Okay.
And did go to the assessor's office and did find the assessment card. I'd just like to note, I find it interesting
Oh,
that,
go ahead.
that you said when you went there was no bottom notation for the finished basement. When I went there on last week at some point, there is a bottom notation showing 1,196. It does say finished recreation area, but it's clearly in a different handwriting than the rest of the notations, and the front of that assessment card does show that Joseph Rist on June 27th, 1995, allowed the assessor into his house to make these observations. And at that time, the assessor did not observe a finished basement.
When I went and looked at that, that was not there.
Okay.
Go ahead.
It's even more interesting. Just to address the time period, I mean, I think that's, it was on August 12th that we received a copy of the plans. It was on August 12th that
Can you tell us why you didn't file it till October 10th?
I believed that my office had filed it, and then there was some communication with you in an email that said that we were on the agenda.
Yes.
And then it was corrected that we were not on the
was
agenda.
a mistake.
But at that point, I believed that it had been, and it was after that we discovered that we didn't, and took it to, or that the building department had not received it, and I went there and I met with them, and that was on October 10th.
Okay. Is there anything else?
I think that's it. That's, it's essentially, everything else is laid out
Just
to
so
the
the
board.
proof that you have that you filed the appeal is the stamped copy,
That's correct.
correct?
That's correct. And that is of October
'Cause
10th.
I think that's all the board has. I just wanted to clarify the record.
That's correct. That is what we provided to the board, and that's the October 10th date is the date
Okay.
that we were using. Just to speak to two items from before. B2 of that section, the first word there is notwithstanding B1. So it means if, it doesn't matter what B1 says, B2 still applies. So the 25% increase certainly does still apply. And the applicants did, I'm sorry, the homeowners did spend a lot of time discussing this floor area and addressing it in their papers. So it was something that they certainly had considered previously.
Just to clarify your position, because you mentioned it, is it, as I understand the code, that if there's a pre-existing structure
Yes.
that doesn't increase any dimensional nonconformity, but increases by 25% or more the floor area, that a special permit would be required?
If there is a non-conforming structure and there is an increase by 25% or greater in the floor area, then yes,
And just
that's my
so,
contention.
in that circumstance, a special permit would be required, is that your
That's
understanding?
correct, that's correct.
What is your client's position on that special permit issue?
Their position is that none was obtained. There was no special permit obtained prior to the granting of the building permit.
And if they were to seek a special permit?
If they were to seek a special permit and one were, my clients would certainly speak at that time as well, I'm sure. But they have said in the past, if one was granted, that is up to the zoning board of appeals. And if the zoning board at that time saw it fit to grant a special permit, and if I'm speaking out of turn, they can certainly correct me, but that's what they have expressed to me in the past, that, procedure and needed to be followed here,
So
and if.
their feelings is that the procedures should have been followed.
And
I mean, the procedures they think is right should have been
I
followed.
think so, and, they are the adjacent neighbors, but this is certainly something that other members should have had, members of the community should have had an opportunity to comment on.
Right.
It's a larger question than just this one individual home, and that's.
Right, I understand what you're saying. Okay, anything else?
I have nothing more to add.
Dr. Romero, would you like to speak, or Mr. Babcock, or would anybody else in the audience like to speak to this? Yes, sir. Well, you have to come up here and tell us who you are.
Hi. Matt Francisco, I chair the Village Cold Spring Planning Board, and I was also a trustee when Peel Hall case, the shed case came. I can assure you the applicants, I knew their concerns, they had full access to the records, so they had very timely access to know exactly what was happening. I think
Cold Spring, you're saying? This is what
in Cold Spring, yeah.
So you're talking about the shed in Cold Spring?
Yeah,
Okay.
exactly. The case that was cited, which
Correct.
is relevant here, but it's different, right?
Right.
And I think as Member Claire had said, which I think is really spot on to my view, is if there is any way that or any concern that they didn't have access to the record, all you can really assume that, the neighbors would know once they have constructive notice, they're ripping the roof off, is that somebody is following the code and they're not increasing it by greater than 25%, right? You need the plans to really understand that something very different is occurring. And I think that is a very clear distinction between Peel Hall versus the Village of Cold Spring and what's happening here. And I was really happy to hear Member Claire's, view on this, because I think it would be my position as well to say, let's take an abundance of caution and just say, let's talk about exactly when that 60-day clock runs, respectfully. Thanks.
Okay. You're on I'm sorry, you're the chairman of the?
I chair the planning board.
The planning board in Cold Spring?
Yep.
The one I'm talking about.
Great. Thanks.
Okay, thank you. Is there anybody else who would like to speak to this? Okay, yes. You're the contractor, right?
Yeah.
Okay,
My name is Tom Potachik, and I'm the builder on this project. And I just wanted to clarify the issue with the basement that you keep talking about. Most basements, every home needs an insulation envelope to pass current energy code. You can't leave an open door in your envelope. You can't leave, you need to be able to circle the house with a layer of insulation that's required by law. So the insulation,
in the basement, is that what you're saying? By
yes,
law?
the basement has to have either the basement floor or the basement walls have to be insulated
So you're saying that
by
probably
code.
80% of houses in this area that have
They're not-
basements
they-
that
they
are not
don't-
finished
they-
are illegal?
No, they do not comply with
code?
modern code that has just been,
What code is that? What code number is that?
the New York State residential building code that the town of Philipstown is adopted.
New York State?
Yes.
So have we adopted that code?
Yes, and we need
Can
to,
you give me a section number?
no, I don't have a,
Can you give
this
me a
is stuff
copy
you're
of it?
supposed to
Can you-
know.
Can you provide us with a copy?
Yeah, we can. We
Okay.
can. Okay, so you're supposed to have insulation around your house, including under your feet or in your basement, especially if you have plumbing pipes down there.
Okay.
You're not going to leave that outside of the envelope. And if you have ducts that service the floors above, you're not going to leave that outside of the envelope because it wastes energy. And the whole point of modernizing the energy code is to burn less fossil fuels, okay? So these walls are insulated to meet the energy code.
sheetrock.
And they have to be sheetrock to meet the fire code.
Okay.
And that's the way things are gonna
But
be.
they can't be just regular walls? When you
Not,
finish- when you
those were
unfinished-
block walls, uninsulated block
when
walls
you
that were
unfinished-
original.
Okay, when the basement was finished, right, this basement we're talking about, because you
Yeah.
said it was finished.
Yes.
And then you unfinished it, right?
Yes,
Okay.
because it was
So you
rotted.
take out all the sheetrock and all the insulation?
Yes, we took some walls, I can't remember what it was, but we took finished walls apart. Whether the old walls had insulation, that was back in the sixties when they didn't build like we do now, that's required. And now we have to provide an insulation envelope around the whole living, tempered space.
Okay.
And so the envelope that since it's exterior walls in part of the basement, it's not all underground, we use a closed cell spray foam, and it's also a lot of moisture coming in, so we use a closed cell spray foam to stop the moisture and the cold from coming in. And by code, that has to be fire-proofed and with a Type X sheetrock. You can't leave it open even in an attic, you're not supposed to leave it uncovered.
Okay, so you're saying that a basement in a house, in this area,
Yeah,
you walk down, they got the washing machine or whatever like that, and all the walls are bare. They're illegal?
not illegal.
Or what are they?
They're grandfathered. They were
They're
built
all
in a time.
grandfathered. How do you know they're grandfathered?
They're built in a time before this code was.
They're not all built in a time before, because there's plenty of ranch houses
The
that are
modern
built-
day code requires this.
Okay. Thank
And
you
this
very
you
much.
should, you could find out from the building
I have-
inspector.
Thank you
I
very
have a
much.
question. What material were the walls of the previously finished basement did you take out?
I believe there were wood paneling. It was covered with mold and mildew. And
Wood paneling?
yeah, some sort of wood paneling. That's my recollection. We have photographs of that.
And sheetrock or no?
I don't know if it was sheetrock or not. I can't remember. But it was we took the walls, we stripped the walls of a finish. Because I recollect seeing everything dripping with water from the condensation.
So they would have put wood paneling without sheetrock?
Somebody did. This house was built by the owner, and there was numerous things that were not compliant. We had 2x6 roof joists in that house that we took out. That was never, it was not built to code to begin with. But that happens in a lot of homes. Homes that are built in the 1870s have 2x4s sometimes as rafters. That doesn't mean that they're illegal. That just doesn't mean they're brought up to the current code. And when you build or strip an existing home, you're required to build it. If you add on a substantial percentage, or if you build a new home, you're required to bring it up to code. Okay. So now the modern day code says you have to have insulation surrounding the house, not just on the walls and
Is
ceiling.
there insulation behind the wood paneling?
No, I do not believe there was. And that's why there was so much moisture coming straight in through the block.
Okay, so you're saying a modern day code basically says you have to finish the basement. Is that what you're saying?
No, I'm not.
What are you saying
I'm
then?
just
I'm
saying
lost.
it has to have an insulation envelope. And that
sheetrock?
insulation envelope has to be meet fire code.
So it has to be insulated in
Can you
sheetrock.
is it smart to leave a basement ceiling with paper back
The question I asked you, does it have to be insulated in sheetrock?
It has to be insulated and brought up to fire code.
Sheetrock.
There's different ways of bringing it. I didn't say it has to be sheetrocked.
Thank you very
But-
much. Anything else? Thank you.
Thank you.
All right, there's only 3 people here tonight. Unfortunately, Mr. Sestone is missing. He has the flu. So it would be disadvantageous to each person to call for a vote tonight. The reason being it would have to be unanimous, okay? Meaning that one person voted, we all have to vote the same. So if you have Mr. Sestone, it could be different. It could be 3-1 or so on and so forth. So it's not fair to either party to vote tonight. So what I'm going to do is I'm going to ask to close the public hearing, and I'm going to schedule a vote for next month, which would be March 2nd. Okay, I make a motion to, go ahead.
Mr. Diab, in terms of closing it, just because we've been presented with,
You want to leave it open?
well, I'm just saying that we were presented with information that apparently there was some dialogue I heard from some of the applicants about having perhaps Mr. Warner address. So I'm just saying if there's an open question on some issues,
Okay.
that would give the board flexibility to hear it if they so choose.
Okay. I'm concerned that I don't want to be deluged with more information
Yeah, but-
between now and then, you know, I'm trying to say, from the attorneys.
I mean, limited to supplementing some questions that the board had from Mr. Warner, based upon issues of the size, issues that I've heard about, upgrades to the basement. Does that constitute finishing a basement or unfinishing a basement?
Okay.
I thought you also wanted to know if there was a CO,
There is no CO.
so then,
There's no CO. I'm just asking each attorney, is there a CO for a finished basement? Mr. Schilling? No. I'm so sorry. There was a question, is there a CO for finished basement? I guess.
Mr. Chairman, I would have to review the building department
Oh.
file to see exactly what was there.
Well, I reviewed them, I didn't see it. I just thought maybe if you found it.
And again, without reviewing it and not having it in front of me, I wouldn't be able to provide you with an answer of whether or not that basement was legally pre-existing prior to the code.
Okay.
I would like the opportunity to review that. I'd also like to provide you with the definition of finished basement, unfinished basement, and then also look to some of the other items that Mr. Rod has just brought to our attention.
Okay, all right, you're entitled to the same thing, Mr. Hilbert, if you want to add the
That's fine.
information.
I did, I also looked at the building department file.
All right, so we'll keep on advice of the attorney, we will keep the public hearing open.
Right, and in addition to that, there are some issues that Mr. Hilbert had brought up in this letter that he put on our desk today that I would want to explore.
Yes.
Okay? All right, I might make a motion that meeting be adjourned.
I'll
There a
make the
second?
motion.
All in favor?
Aye.
Okay. Till next month.